Oh, yeah. All right, clerk will close the roll.
Ayes 8, nays 7.
All right, your bill reports.
Thank you.
And 734.
Yes. 734 is a bill that would provide for the audiovisual recording of custodial interrogations where practicable, but makes clear that failure to make such a recording will not affect the admissibility of any statements made during that interrogation, but that the court can consider, and the jury will be instructed that they can consider such failure in weighing the evidence of such statements. The bill also would require the DCJS to establish, publish, and disseminate a model policy or guideline for law enforcement personnel for the recording of custodial investigations, and provide that the length of any interrogation shall not be unreasonable, and a person subject to such interrogation shall be permitted reasonable periods for rest and personal necessities, such as going to the bathroom. This bill was originally a recommendation of the Innocence Project, that back in 2015. It was drafted in consultation with law enforcement to address the growing concern over false confessions that have led to wrongful convictions. And this year, the Roosevelt Institute at George Mason University, which is a nonpartisan student-run think tank focused on drafting and implementing policy proposals, requested that this bill be put in again this year as part of 10 bills that they sought to have introduced. Between 1989 and 2017, 47 Virginians were exonerated of crimes, and 27 of them, the exonerations were due to, or the original convictions involved false confessions, perjury, or false accusations. And there is a growing concern that particularly among individuals with disabilities, but not exclusively, that sometimes in an interrogation, someone will confess to something they didn't do. And I think the idea behind this bill is, one, to protect the person being interrogated so that someone can sort of view that interrogation in context, but also to protect law enforcement, because sometimes accusations are made against law enforcement that a recording would put those allegations in context and sometimes exonerate law enforcement themselves. So I believe the bill is pretty straightforward, but would be happy to answer any questions.
All right, anybody have questions of the patron? I suspect that the Commonwealth's attorneys have some thoughts about this. Unless anybody has any questions at this point in time, let's hear from the Commonwealth's attorneys. Maybe even the sheriffs have some thoughts about this.
Thank you again. I'm Theo Stamos from Arlington County in the City of Falls Church on behalf of VACA. We do oppose this legislation. What it does is essentially codify the notion that police officers are inherently untrustworthy. The problem that we have is the judicial instruction to a jury that unless this has been recorded, you can give minimal weight to the testimony of a police officer that indeed a defendant made an admission to an offense. I mean, the good defense attorneys are using an argument along these lines every day anyway. So we would oppose the codification of that assessment of police officers.
Thank you, Ms. Stamos. Ms. Jones.
Mr. Chairman and members of the committee, I'm John Jones representing the sheriffs. We do oppose the bill. We think it goes a little bit too far, especially the language on line 247 that it says the interrogation means any interview conducted by a law enforcement officer, and it goes on to talk about it. It just goes too far to accomplish it. We don't have the equipment to do it everywhere. We do understand it should always be done at the sheriff's office, and if we get funding to buy this equipment, we'll take a look at it. But this is out in the field.
All right, thank you very much. Anybody else wish to speak in favor of or in support of or in favor of or in opposition to this bill?
I know there was a student from George Mason who, as of last night, was trying to get here, but I assume the weather kept him away.
I'm sorry about that. Anybody, Steve?
Mr. Chairman, I can tell you that the bill does address a real need in the criminal justice community, and what we have found is that any time that we can record any incident of an arrest or an interrogation, we're rewarded with better accuracy. There's nothing more frustrating than arguing with a client or an officer about what was or was not said during a confession. And it's so much better if we can answer that question with definition. I don't think, and a further value to this is that by recording somebody's statements and their demeanor during the time of a statement and an interrogation, you also capture their mental state at that point, which can be relevant. In any event, I would suggest to the patron that no harm would be done to the bill if the subsection D, which the Commonwealth attorneys spoke to, the instruction that the failure to make a recording, I think if that were deleted, it would do no harm to the spirit of the bill. Moreover, the subsection B, the length of the custodial interrogation shall not be unreasonable. I don't think that really adds anything to what the circumstances would be anyway. I suspect that the real essence of the bill is subsection C, which does not mandate that interrogations be recorded, but only says that if it's practical to do so, you should do that.
Mr. Chair.
I think that's a very good point.
Mr. Chair,
Senator Peterson.
I'm going to make a motion and then speak to it, and I'll say I'm sorry.
Before you do that, my student is here,
Yes.
Andrew Millen, if you'd like to hear from him since he drove all the way
Yeah,
from
you bet,
Fairfax in the
please.
snow.
Yes, sir.
Thank you. Good afternoon. So my name is Andrew Millen. I'm here testifying in favor of this bill. I'm a member of the Roosevelt Institute, which was described earlier. So what this bill does is two things, as have been explained, but first, it recommends interrogations in Virginia be recorded using audio-visual means based on Department of Criminal Justice Services guidelines. Second, it also limits the length of interrogations so those being interviewed can rest and eat, which I think is also a very important part of this bill. And the precedent for this legislation is clear. In 2003, Robert Davis, an 18-year-old from Albemarle County, was convicted of a murder he never committed because he was falsely accused, then coerced into a false confession during a 10-plus hour interrogation in which he could not sleep or eat. And after nearly 12 years in prison, he was exonerated in 2016. His story is not unique either. As was said earlier, 47 Virginians have been exonerated between 1989 and 2017, and 57% of those were because of false confessions. In 2016 alone, 3 of the 4 exonerations were because of false testimony, and the combined time lost between the 3 was 46 years, as well as possibly hundreds of thousands of dollars or more, keeping those innocent people locked up. Every year, there are more and more innocent Virginians found, and many are due to false confessions. So I think this bill is a great first step in increasing accountability, which is voluntary for localities, protects the constitutional rights of those accused, as well as the officers and police departments from costly future lawsuits. Thank you.
Thank you for your efforts and being here. Thank you for your research and your insights on this bill. Appreciate that.
Thank you, Mr. Chair.
Hang on a second.
Yep, I'm sorry.
Before you make a motion, I think there were a couple other questions. Is that okay?
Sure.
Okay. Senator Reeves.
Thank you, Mr. Chair. I just had a question for the patron online.
Any other location which persons are or may be held in detention. So theoretically, that's anywhere. Is that safe to say that would be catching a bad guy coming out of a window on a B&E on a breaking and entering, knowing he's not the resident, coming out and finding out there's more people inside the building to which he was burglarizing.
You turn your mic.
My mic's not working. Would I have to?
I'd say the patrol cruisers more.
I would have to then videotape my conversation with the suspect in custody, right?
Mr. Chairman, this bill does not include investigative detentions, which is the situation that Senator Reeves seizes someone who appears to be escaping from or committing a crime. That would be a detention subject to further investigation. In custody refers to the more formal attributes that go along with a formal arrest. And in addition, it wouldn't be practical in the situation that's described, and so this bill would not mandate a recording at that time.
Thank you, Mr. Benjamin.
Any other questions? Senator Peterson.
Yeah. First of all, I want to thank the patron and thank my constituents that came down from George Mason. Two things I'd like to make a motion, and one is to take out subsection B, which talks about the length of the custodial interrogation not being unreasonable. I'd like to remove that, lines 254 and 255, and then subsection D, which was previously alluded to, which allows a jury instruction where.
Let's do those one at a
Separately,
time.
okay, then I'll move the, taking out the editing or deletion of subsection B. Make
All
that
right,
motion.
there's a motion. Is there a second? All right, it's been moved and seconded to delete subsection B. Any discussion of that? Any objection?
No.
All right, all in favor signify by saying aye. Aye. All opposed? That amendment is made. Second amendment?
Second amendment would be the subsection D, which is the jury instruction issue that Commonwealth's Attorney Stamos spoke to, that I think I can see how that would be both confusing and well, I'll just leave it at that.
Well, let me
So
ask
I'd make that
counsel about that. Well, is there a second to that motion? All right, let me ask counsel, if we take that out, does that not allow or permit a defendant to challenge the admissibility?
Yeah,
No.
Mr. Chair.
Well, I mean, isn't that part of what D says is shall not affect the admissibility of the statement?
Well, it's saying that, but I don't think even that is necessary. If that causes any qualms, then that could remain in a separate subsection D. The failure to record shall not render a statement inadmissible. There's no harm in leaving that in.
But then what's the statute do?
Well, sorry. Do you want to answer? So you would still have DCJS implementing a model policy. You would still have, where practical, that custodial interrogations would be made, and that the audio, if such an audio-visual recording is made, that it has to be preserved pursuant to Section E. And then you would, if you amend the amendment, such as Mr. Benjamin suggested, you would keep the savings clause that the failure to record would not keep that statement out.
Mr. Chairman, yeah, and I think the patron is right. What this is it doesn't mandate recording. It strongly suggests it. And I think the committee can view this as an aspirational bill, a bill that aspires towards greater accuracy. We all know from present circumstances in Washington that U.S. senators can disagree as to what was said during a particular meeting. By using technology that's available to us, and if an officer has a cell phone, he has the equipment, it promotes accuracy as to what was said or done at any particular point.
Mr. Chair.
Hang on, Senator Stewart.
Senator Peterson, would you consider a friendly amendment to your amendment in subsection D if on line 260, after interrogation, you struck everything after interrogation but left everything in subsection D up to that point?
I'm fine with that.
And then I think it makes it clear.
All right.
Steve, do you follow what I suggested? So
Charles, you got it.
subsection D stays in, except you strike everything after interrogation in subsection D.
All right.
But I still have a question.
Is that your amendment, Senator Peterson? All right, without objection. All right, Senator Stewart, you had a question? All right. The amendment is before us. Anybody have any questions about what the amendment is? All right, all in favor of the amendment signify by saying aye. All opposed, the amendment is adopted. Senator Stewart.
Thank you, Mr. Chairman. Senator McClellan, the only question I have is there's a pretty significant body of law on what would lead a reasonable person to believe they were in custody. Sometimes that can be on the side of the road with a vehicle. Sometimes it can be in other places, just depending upon the circumstances. And I'm not even sure I understand all that law, but I've researched a lot of it and dealt with it. and I don't know if I should ask you or Steve or somebody else, but what does this do to that? Does that do anything to convolute it?
Mr. Chairman, Senator Stewart, it does not. The law in Virginia right now is fairly conservative about what constitutes someone being in custody for these purposes. You can be handcuffed, for example, and still not be considered in custody. And this
But
does
not be
change that.
handcuffed and be in custody.
It's fact-specific, but this does not change that.
And Mr. Chair, all I'd add to this is back in 2015, when I first had a version of this bill that did include that same language. That language was drafted in consultation with law enforcement and constitutional law experts, and at the time they were comfortable with the definition of custodial interrogation. So I think they considered that in 2015 and didn't have a problem with it.
Mr. Chairman.
Senator Stewart.
So, Senator McClellan, with these amendments, is it your intent that this bill just be aspirational to try to encourage officers to record as many of these interrogations as possible?
Yes, but if they do record it, I think that the provisions of subsection E are very important, that recording be preserved until the conditions there are met, and also having the model policy by DCJS, I think, is an opportunity for law enforcement to share best practices. Recording custodial interrogations is very quickly becoming a best practice, and I just sort of want to make sure that that if nothing else, if that policy is made available, I think that might be helpful.
Mr. Chairman. Sorry, I have another, that draws another question. Maybe Senator Northam knows the answer, but are the courts capable?
Going in different directions, so why don't you finish, sir?
Well, the court's capable of I'm thinking of general district court. You have a preliminary hearing on a matter and it goes up or not. Are the courts, and maybe we need to hear from the courts, are they capable of preserving this information for this duration? I don't know the answer to that. And I'm not trying to be an impediment, Senator McClellan. I really am thinking through this as we go.
I mean, again, all I can say is when this was first drafted in 2015 and we consulted with the courts, they didn't have an issue at the time. And I have not heard from them since, so.
All right.
Okay, thanks.
Senator Norman.
Senator, I pretend to practice in this area on some occasions, and since 2015, I think from a technology standpoint, there have been some interesting evolutions, and one of the senators just mentioned that technology is available if the officer has a cell phone. But also there has been a terrific enhancement in the use of body cams, which has had a number of consequences. The dash cameras that are there, and I very easily can see myself arguing about the admissibility of a statement in the absence of an officer who had a cell phone, had a dash camera, had a body cam, but just didn't have it on at that moment when the confession or the statements against the interest of the defendant were made, and that causes me to pause.
Mr. Chairman?
Senator McDougal.
It's more than a hypothetical. I can think of an argument recently where two officers responded to a situation after they docked their body cameras and went off duty and made an arrest. And so, but they were still in uniform, displaying a badge authority, marked vehicle. And so would any of the statements made during that encounter then be eliminated? And if they were to be, then that would clearly create some challenges.
Mr. Chairman, I can tell you, I can assure you that those statements would all be admissible. Absolutely, no question.
And I think lines 258 to 260 make that very clear.
All right. With these amendments, the Commonwealth's attorneys and sheriffs have a change of heart? Yay or nay?
Yeah, our big issue was the jury instruction regarding the serviceability of the trustworthiness of the testimony. So if it's the aspirational goal, then we support it. I mean, we love our confessions to be audio taped and
All right.
videotaped.
John?
No, still don't like it. 249 is my problem with it, Mr. Chairman, if you want me to
All
go into it. It says which a law enforcement officer takes actions
Got it.
or asks questions.
Got
That could be, hey, I want to talk to you.
Got it.
We got to record it?
Motion, bills before us.
Mr. Chair.
Senator Peterson. Report.
Technically, from a legal standpoint, have to be in custody. It's if they believe.
Sports team in Northern Virginia. I've talked to certain players who feel like they've been targeted, okay? So this is gonna, once we get these practices out there, this is gonna make things at least more understandable. So I think it's a good idea.
All right, is there a second? Second. All right, it's been moved and seconded the bill be reported. Any further discussion?
Yes, sir.
Senator Norman.
I'm going to vote against the bill for a number of reasons. And I think when we get into criminal law and you start dealing with objective and subjective issues, on line 48, it causes me to pause because of the standard that is created there, and it's a definition, your definition of custodial interrogation. And the standard is, would lead a reasonable person to consider himself to be in custody. A reasonable person perspective might vary significantly between that of the ever astute Mr. Benjamin and Joe Sixpack, who's been stopped on the street.
All right. Clerk will open the roll. The motion is to report.
Ayes 6, noes 9.
All right, the bill fails support. Thank you
Thank
very
you, Mr.
much.
Chairman.
And before I forget about it, the General Laws Committee may be a little vexed with me because the bill that I